So today we're going to discuss ways in which hospitals will defend cases when a baby has a traumatic brain injury at birth through their lawyers, how these lawyers will represent and defend the doctors and nurses and the hospital. And essentially what we're talking about, what I'm going to discuss today is 3 ways in which essentially the hospitals are blaming others as to why this baby has this traumatic brain injury. When I'm saying others, that's also including parents. So there are others that are in this conversation, but I'm just going to talk about the 3 main ones today. The first one being is genetics or developmental issues or challenges. That's the big one. What they will say is that, no, we could not have caused your baby to suffer this traumatic brain injury because it had to be genetics and it had to be developmental. And I know that this can be problematic for some families because when I talk to families, a lot of times they will tell me, it's like, look, I didn't even think that medical malpractice could cause this, because a lot of literature that you see online and a lot of things that you see in some of the scientific journals and things of that nature, they only mention genetics and they only mention developmental. They rarely will talk about medical malpractice as causing a baby to suffer a traumatic brain injury. When the truth of the matter is that, yes, medical malpractice can, in some cases, cause a baby to suffer a traumatic brain injury. So that's just something that you have to understand. A lot of times they will push hard on this genetics aspect of things. And I will just quickly tell you a quick story about a client that we had in the past in which this family, they weren't even going to move forward with a medical malpractice case, in which, in our opinion, their baby suffered a traumatic brain injury, this HIE brain injury, because of medical malpractice. But they weren't even going to go forward with it because they were told that their baby had genetic things that were going on, or genetic challenges. And as time went on, they begin to doubt that genetics was at play, because their baby should have been displaying certain types of signs and symptoms based on this genetic condition, and their baby wasn't doing it, wasn't displaying these things. And so they got a second opinion. They got a couple of second opinions, and those doctors looked at everything and was like, no, this is not genetic with your baby. This is not genetic. Your baby is not meeting the criteria for this specific genetic condition. So genetics is one big way in which they will look to blame something else, which is essentially the parents, for the baby suffering a traumatic brain injury. The second one is going to be what they will go to is umbilical cord pH scoring. So when a hospital, when they're thinking that a baby may have had a traumatic brain injury at birth, with certain things that are present, for example, if there's meconium and there were probably an electronic fetal heart monitor or on the strips, then hospitals may order readings or gas reports. And normally what you will see is that a umbilical cord will include an artery and a vein. Usually it's going to be a 3-cord vessel, and that will include an artery and a vein that will be in there. The normal reading for a vein pH scoring is going to be about 7.35. For the artery, that's going to be about 7.28. These are in the normal ranges for these types of readings. And what will happen is that if you have a pH scoring that is in the, quote, normal range based on the ACOG guidelines and some of these other guidelines, what the hospitals will say is that we could not have caused this baby's traumatic brain injury because the pH scoring or the umbilical cord gas report is in the normal range. Now, there are things that can happen which can lead a baby to have a higher umbilical cord gas scoring, even though an injury happened during labor and delivery, because you need to know, was mom resuscitated? Was there oxygen being given? A whole host of things that you need to understand, which can, in some instances, impact the readings for the gas reports. But what the hospitals will say is they will say that, well, because it was in the normal range, then that means that we could not have caused it. So that's one big way in which they will defend these cases. They will look to see what is that reading on the umbilical cord scoring, what is that pH, where does that look, what does that look like, and they'll make a decision from there. The third one, and this is a big one too, is going to be imaging, specifically the head ultrasound, that first initial ultrasound, which is generally done within 24 hours. That is important. The initial MRI readings, that is important, but specifically that head ultrasound. And the reason why is because their position, or the defense position, is going to be, in a lot of cases, that if that initial ultrasound is showing, if it's positive and it's already showing an injury or there's already issues there, they're going to argue that it takes a certain amount of time for an injury to show up. And that if that injury is already there and that within that early window, then that injury for the brain had to have happened earlier in pregnancy. That's going to be their position. So they're going to be looking to see what does that initial head ultrasound look like. Now, there are other things that you can take into consideration and argue when it comes to the head ultrasound, and using specific types of studies and depending on what your experts may tell you as a plaintiff. But I just want to let you know that these are some of the areas, especially with that imaging, in which they are going to go. Now, I know I've said a lot, and hopefully you're still with me, because what I'm going to do is I'm going to connect all of this together right now. And what I'm going to say is that this is why, as a birth injury lawyer, this is why these cases are extremely complex. Just listening to what we're discussing today, this is a lot. And when clients contact us and when we talk with families about these types of things, it takes us time to get through an investigation and get through these records to be able to make a decision as to whether this is something that we think that we can help you with. Now, I'm going to talk specifically about myself and my law firm, my partner, Renee. When we are looking at these cases, we have to feel very confident about what we have going on, because these cases can take a long time. And I don't think it's fair for me to put a family through cases or through something like this, and I don't have these issues buttoned up. I don't have, let's say there's issues with the cord pH. I don't have a satisfactory answer for why this cord pH is the way it is. Or let's say there's issues on the electronic fetal heart monitor that I can't explain, or my experts don't really have a good grasp on, or they can be attacked with other positions based on what is being seen on the strips. These types of things have to be things that we have a good feeling with, because like I said, these cases can take a long time, and I just don't think it's fair to put families through this. And I think that there are problems with the case, or I don't think that if we have to try it, I don't have good explanations to the jury for these types of things. So this is why, and this brings up another point. This is why, if you're taking that wait and see approach, especially if you've got a statute of limitations, you're in a state or jurisdiction where you have a shorter statute of limitations, this is why you have to be extremely careful, because you want to be able to give the lawyers time to not only investigate on their end, but to be able to also talk to and get medical experts that they're going to need to be able to review the strips, to be able to review the medical records, to be able to review the placental pathology if that was done, to be able to review the umbilical cord pH and the scoring. All of these types of things have to be looked at, and you have to have these things analyzed and reports generated if those need to be, and depositions prepped for these types of things. There's a lot that go into this. So I'm just taking this time. It's a little bit longer video, but I'm helping you to understand all of the things that, or some of the things that go into these types of cases, moving them forward, and how hospitals are defending these cases. As I said in my previous video before this one, they fight like hell with these cases, because if the cases do settle, or if you do win a jury verdict, generally this is going to be in the millions of dollars range. And these hospitals are not trying to just, willy-nilly lose that type of money or pay out that type of money without doing their research and not putting their defenses forward too. All right, that's going to be it for today's longer educational video. Again, I'm Marcus Boston, and I'm one of the childbirth injury and medical malpractice lawyers practicing law at Boston Law Group LLC. We'll talk with you next time. Take care, guys. Y'all enjoy the rest of your day.